Well, good afternoon and welcome to this next in our speaker series. We're very fortunate to have with us today Professor Jennifer Chandler from the University of Ottawa. She's on faculty in the Common Law section. She's recently been a visiting associate professor at the Center for Biomedical Ethics at the National University of Singapore. She's previously practiced with a national law firm. She clerked for Justice Sapinka at the Supreme Court of Canada. She's a well-known health law scholar with current work on the law and ethics of neuroscience, which gives rise to her topic today, Rewiring Criminal Offenders, Challenges to the Criminal Justice System from Emerging Neuroscience. So please join me in welcoming Professor Jennifer Chandler.
Thank you very much, Dwight, and thank you all so much for coming. Can I just ask if you can hear me? Am I projecting to the back? Is it working? Okay, great. Okay, well, let me get started. I'm very, very interested in biomedical technologies. This is the direction that I come at this from. I've taught in the area of the philosophy and sociology of technology and have done work in a variety of biomedical technological areas, but I've always been most interested in the brain, the mind, and especially now with what appears to be a bumper crop of neuro everything. I'm extremely interested in neurolaw and neuroethics. The topic I want to discuss with you today is something that is the subject of a research project that I'm about to get going on. And it is basically asking this question: what treatments can an offender be required to accept in exchange for liberty? I'm going to talk about this, unpack it for you, and explain the relationship to neuroscience in a moment. But I want to just give you the example just to motivate the question of the Deacon case from 2006 Federal Court of Appeal of a man who was under a long-term supervision order, a convicted sex offender, and who was told one of the terms of your long-term supervision order is that you will consent to whatever medical treatment is recommended by your treatment team. This is not uncommon in the context of long-term offenders. And the recommended treatment was anti-libidinal drugs, colloquially chemical castration. And he objected. He said, I don't want to take this. There's side effects and I don't really want it anyway. To which the court said, well, you have a free choice. You can take what's required or you can stay in jail. And there's no constitutional charter right to refuse all medical treatment anyway. So this is fairly common within this set of offenses, and especially serious offenders, long-term offenders, dangerous offenders. And so Weigel, talking later on, says, well, numerous decisions supporting the legal obligation to receive sex drive reduction medication or be denied release into the community. And I give you this example to illustrate that this question of legally, I can use a loaded term, coerced, we can say encouraged, pressured, but this legally influenced consent to treatment is an aspect of our existing criminal justice system. So why ask this question now? What's the intersection with neuroscience? Well, a couple of reasons why I think it is very interesting and important to ask this question now is, first, we don't have at this point a clear consensus on the philosophical justifications of punishment. There was a near unanimity through the 60s that punishment was justified by an aim to rehabilitate. That was the function of punishment, contra to a retributivist model or justification for punishment. But there's been a retreat from that. There's questions about whether can we ever rehabilitate. Are we now in a risk management mode where we want to incapacitate rather than to rehabilitate? Are we back in and some would say we're back in a retributivist mode where we say criminals are just bad and retribution is sufficient justification for punishment? So we have an unstable philosophical context here. We're not quite sure what exactly punishment is supposed to be doing, and we're not quite totally sure what the philosophical justification for what we're doing is. Add to that a system that's already quite amenable to legally coerced treatment, and I'll track through some of the stages at which this option is put to an offender: treatment and liberty or imprisonment. So it's already set up to receive treatments as they come into existence. Third, neurobiological explanations of criminal behavior are proliferating. There's a vast literature. If you just look into PubMed, a vast and growing literature, PubMed, psychopathy, fMRI, you'll see a bumper crop of papers describing the various kinds of structural and functional abnormalities in the psychopathic brain, amongst other kinds of psychiatric or behavioral problems which are overrepresented within the criminal justice system. So we're getting all these stories about how it's a function of the brain structure or function. And all of these explanations are joined by emerging ways to intervene into the brain. So not only are we getting more explanations for, let's just call it criminal behavior at the neurobiological level, this is itself suggesting targets for intervention, and add to that different ways of starting to intervene with different kinds of drugs and drug pathways and physiological systems. So we have that kind of exploding in sort of activity as well. And then finally, public is fascinated with the science of the mind. One can find in just about any public sort of media publication discussions of neuroplasticity in the brain region for this, that, or the other. These are explanations that are very appealing for some reason to us, and may perhaps lead to an excessive optimism about what can be done to change behavior, change human problems, solve social problems. And another reason why we should ask this question, think about it, is criminals are not very popular people, especially certain classes of criminals, and therefore there's perhaps a risk that we will be more apt to try to solve them as a problem with these interventions, and maybe a little too fast. Maybe we will close our eyes a little bit to some of the risks and questions about efficacy in the rush to try to solve this problem. So these are my reasons why we should ask this question now. So let me step back a little bit to try to put this in a bit of historical context, because there's nothing, I was going to say there's nothing new, that's not true at all. There is some new, but not everything's new. We're in a bigger historical context here of biological criminology. And I put up, this is my plus ça change, plus la même chose slide here. Cesare Lombroso, back in the late 19th century, mid to late 19th century, sort of founded this field of criminal anthropology. He said, lo and behold, we can look at people's skulls, shape, the extent to which their jaws protrude, other aspects of body shape, and we can detect the criminal type. And this is an atavistic, a throwback, a primitive form of human being. And we can identify it by body shape, measurements, craniometry, things like that. So he has this sort of elaborate description of body type. And notice what happens here. You're identifying criminality as something that's constitutional. These are not things that change, right? It's an aspect of your body type. He didn't have necessarily a hereditary story to this, although this did come later with evolutionary theories of criminality. But look, these are the pictures then. These are the pictures now. Now, we're not looking at the outside of the skull. We're looking inside for different patterns of activation. This is from a abnormal temporal and prefrontal cortical gray matter thinning in psychopaths. So it's structure, looking at structures in the brain. But there's a whole array of studies looking at functional aspects of the brain. And this is done with a technique called functional magnetic resonance imaging, which detects patterns of blood flow in the brain and attempts to find the neural correlates of particular behaviors, activities. And so there's a series of papers also suggesting that there's different patterns of limbic activity amongst psychopaths, for example. So there's an interesting parallel. Now, this is much more sophisticated kind of thing that's going on here and is much more likely to sort of generate useful information, but at the same stage, we're inferring between epistemic levels here. We're looking at patterns in the brain and starting to try to make rather subtle statements about what is going on in the psychology of a person, what's in their mind. I'm condensing a tremendous amount of history here, but I want to identify a couple of key themes that emerge from the historical trajectory of biological criminology that play out today. The first is, a lot of this kind of thinking raises this important question of free will versus determinism. These are deterministic stories. There is an aspect of the biology which explains the criminality. And this is to be distinguished with earlier forms of thinking about criminal justice where we weren't so interested in the causes. We assumed you were a bad person, or you were a sinful person, or there's a religious explanation, but you were just bad. You had free will and agency, but you're a bad person. And so what these explanations were doing is saying, well, no, you're not a bad person, you're a sick person, or you are biologically caused or determined. And notice what comes along with that. There's a way in which Enlightenment, humanistic, humane thinking comes along. One's being fairer, and sort of less unfair to someone by accepting what are the causal predisposing factors causing someone's behavior. You're not blaming them at the moral level. So there's this interesting element of rational, enlightened, humanistic thinking that comes along with these causal explanations. But at the same time, what you're doing in identifying people as classes of people who are more determined, so to speak, have less agency, is there's a very important aspect of othering that's going on here too. These are the people who don't have self-control, and we'll explain why. They're not us. We still have self-control. We're not applying this kind of skull stuff to ourselves. So the free will versus determinism is an important aspect of the debate today. The other important aspect of the debate as we go through the history here is one, if we're in the deterministic mode, we can explain determinism as a function of biology, neurobiology, skull shape, activity or structure in the brain, genes, whatever. That's a biological deterministic story. But there's other forms of determinism that have been popular and used, social or environmental determinism. So these at the same time are deterministic stories within the free will domain. Now, a lot of biological determinism came into very, very poor repute with eugenics, with the kinds of racist connotations that came along with it, and actually were an important part of it for a while. And so there was often a very important tension between biological determinism and social determinism. Now we find this as being merged. We have a vision of criminology which is biosocial. And I want to share with you just one study before moving on, which is the 2002 Caspian-Moffat study. This is just slides taken from an image taken from their paper. But what they did was they went and looked for genes within a population of men imprisoned for violent offenses and found that indeed abusive childhood was a risk factor for later developing various conduct disorders and being imprisoned for a violent offense. But if you had one version of a particular gene, your risk wasn't very much elevated by an abusive childhood. If you had another particular gene, it was dramatically, the risk was dramatically raised. So what they were suggesting here is it's not just a biological story, it's not just an environmental story, but look at the interaction between the two. It's a gene-environment interaction. And this is where I think most of this discourse happens now. It's recognized it's not simply a biological story, not simply a social or environmental story, but a matter of our biological organisms interacting with the environment together, producing particular phenotypes. But now, let me return to what does the law have to say about this. Where we see a lot of the discussion in neurolaw now and these neurobiological explanations is around, oh my gosh, we now have explanations for criminal behavior. We've got to completely abandon retributive thinking of criminal justice. No one is morally blameworthy anymore. We're all determined. So it's a very extreme deterministic position. Now, this seems unlikely to me. We've been able to incorporate other forms of social determinism without throwing out the sense that we are still fundamentally responsible. What is much more likely, I think, and we've seen cases of this already, is that the existence of these predisposing factors, the genes or the neurobiological abnormalities, will be used at sentencing as mitigating factors. And so I've just put up for you a little article from Nature reporting on one case in Italy where there was a big neurobiological workup of a woman, actually this one was a man, this one, but there's several of these cases, big workup to identify these abnormalities, these predisposing factors, and then this was used to reduce sentence on the theory that the person was less morally blameworthy because they had these predisposing factors. It's kind of amusing, actually, in the same article, there's a quote from someone saying, well, you know, turns out there's another genetic interaction that explains crime. Most crimes, 90% of crimes are committed by people with a Y chromosome. So the implication then being, okay, now what, right? Do we just say, well, you know, you poor guys, you had a predisposing factor, shorter sentence for you? Well, that's not going to work, right? So Anyway, so that is where most of the action is. And I have a separate project looking at how Canadian courts between 2005 and 2010 have been using this kind of evidence, how it affects their thinking about blameworthiness, about a propensity for rehabilitation, all these kinds of things. But I guess I'm finally getting to my point here, a long kind of preamble, but because what I think is another really important effect of this kind of thinking, this neurobiological explanation, which suggests targets for intervention to us, I think that a very important effect of all of this will be an expansion in the treatments that we will think about applying to offenders. If we come to think of offenses, offending behavior in neurobiological terms, we have more ideas about how to intervene. I think this is going to be where some rather interesting questions will come up. So that's what I want to spend a bit more time on now with you. So very quick sort of description. A lot more could be said here, but I'm going to be quick because I don't want to go too long. If we look at the cases, existing cases now, you'll see that offenders who accept treatment do better on sentencing. Why? Because the court will say, we think the prospects for rehabilitation are higher if you accept treatment, lower if you don't. And rehabilitation is one of the goals of punishment. The other thing is this more sort of moralistically valence kind of thing, is the courts will say, if you accept treatment, you're demonstrating acceptance of responsibility, taking responsibility for yourselves. Perhaps a showing of remorse is mixed up in there. These things tend to play well on sentencing as well, and the contrary, refusal, plays badly. So you can find this all over the place once you start looking. And public safety is mixed up in there too. Long-term offender versus dangerous offender designation, very important whether treatment's accepted. Why? If you're a dangerous offender, you're subject to indeterminate detention. You've committed several very serious offenses, you're considered risky, you just go to jail for a non-determined period of time. However, if there is a reasonable prospect for control of the risk in the community, then you can be a long-term offender instead. And so the distinguishing criterion here is a reasonable prospect for control of the risk in the community, and acceptance of treatment is central to that. I won't talk about these to manage time, but acceptance of treatment or refusal of treatment affects parole. It's relevant in the probation context in a lesser extent, but still relevant. And diversion to specialized mental health or drug treatment courts is usually contingent on acceptance of treatment. All of these are ways of limiting terms of imprisonment, avoiding terms of imprisonment. So that's how this pressure to take treatment emerges within the existing justice system. So let me switch now to telling you a little bit about some of these emerging treatments. And I hasten to tell you that I'm not telling you anything that's done right now. I'm telling you things that are being explored and discussed and thought about. So this is sort of a semi-science fiction-y kind of part of the talk, but I think still sufficiently plausible to warrant our thinking a little bit more about what's going on here. So deep brain stimulation involves the implantation of an electrode within the brain to carefully targeted location to achieve a particular objective, to modulate neurological function in a specific location. And it has been used for quite a while very successfully for movement disorders, for Parkinson's disease, and things like Tourette's syndrome. I was at a conference last winter and saw these remarkable videos from neurosurgeons who would there'd be a tape of someone with absolutely debilitating Tourette's, movement and vocal tics, and then they'd turn on the stimulator, totally normal, walking around, fine. Same thing with Parkinson's disease. It's quite a dramatic effect when it works. But, and this is now fairly recent, only the last couple of years to my understanding, is interest in using this with the implanted electrodes for psychiatric conditions, particularly intractable depression, obsessive compulsive disorder. Now, all of this exists within a broader context of psychosurgery, or brain surgery to affect psychiatric or behavioral change, which has a rather checkered history. And I think people who do deep brain stimulation are very much aware of this and anxious not to fall into the same pitfalls that were attached to psychosurgery. So some say that the old trepanning back in the old day was itself a form of psychosurgery. It could be a form of neurosurgery, but historical background here, I think, that is most salient is the prefrontal lobotomy, which was something that Egon Moniz got the 1949 Nobel Prize for, and became widely expanded in use, especially in the United States. Now, it was not very often used for treatment of criminals, from what I know. But digging around, you find some really interesting suggestive examples. So there's one case reported in the law literature. Meyer writes about it, the recidivist house thief. And quoting from it, he was reporting on an American case in which a house thief's lawyer requested that his client, the court, have ensured that his client had access to the experimental lobotomy procedure to, quote, cure the prisoner of his criminal tendencies. And then Meyer goes on to say, and the kind and humane judge before whom this petition was presented granted it. So there were cases in which this attempt was made to avoid the legal sanction, to accept these quite radical treatments. Schmidt and Schorsch also write about the use in, to address, quote, deviant sexual behavior in a group of imprisoned people in Germany, and this was later in the 60s and 70s, and it's quite clear from reading that article that the motivation to consent was to regain liberty. So, and this was lobotomy as well. So this has been used within populations, criminalized or criminal populations in the past. And in 2006, there was a resurgence of reports of the use of psychosurgery, which is lesions introduced within the brain, not just implantation of an electrode, in the context of drug treatment in China and in Russia. Now, this seems to have stopped again. There's a bit of an outcry about it. But there's examples in which we have been willing to go right into the brain to damage parts of brain tissue in order to deal with criminal behavior. So this is the context within which DBS emerges, and in which perhaps we ought to be a little bit careful about how quickly we would go down this road. So DBS is being explored. There's a handful of about 3 or 4 papers now looking at it to treat intermittent explosive disorder. This is a kind of an uncontrollable rage or aggression often associated with brain injury and cognitive deficit. Also alcohol and drug addiction. A paper doing an elaborate cost-benefit analysis of DBS versus methadone maintenance. What's cheaper to deal with addiction? It's rather interesting that we've jumped already to doing the economic analysis of it. And this is a very interesting paper as well, asking Toronto neurosurgeons, among other questions, the hypothetical question, if we could do lesional brain surgery to treat antisocial personality disorder, highly overrepresented in the criminal population, in the incarcerated population, if we could do that, do you think that would be a good thing to do? And a very interesting quote from one respondent saying, yeah, of course, yeah. ASPD, antisocial personality disorder, is a terrible condition. It wrecks your life, it hurts other people. If we can help, why not? So a suggestion that maybe there's some receptivity to this kind of intervening in the brain to deal with these serious cases. Now, less sort of invasive into the brain, obviously, external brain stimulation, transcranial magnetic stimulation, the placement of or creation of magnetic fields to modulate electrical activity in the brain, or cranial electrotherapy with electric current. And again, the same sorts of conditions are being explored, aggression, addiction, and interestingly, the modulation of social and moral emotions as well. So in the area of social neuroscience, researchers are using these kinds of things to try to change brain function in order to see, this is all part of the project of understanding what parts of the brain do what. If you interrupt this section and observe behavior, then you might have some information about what that part does. And so in social neuroscience, there's a lot of interest in using this stimulation and seeing changes in cognitive, in emotions and aspects of moral reasoning. So judgments of fairness, emotions of empathy, risk-taking behavior, reward-seeking, and impulsiveness can be affected by putting these techniques onto people's brains. And so this has led to people wondering, speculating, could we use these, go in and get a little bit of a zap every week as a form of moral reconditioning to improve the moral emotions in those whose conditions are thought to relate to defects of empathy, defects in social cognition, which, once again, psychopaths, this is one of the defining features. A couple of other techniques. Vaccines there's multiple clinical trials going on now. Here, I bring this up to show you it's not all just the skull. We're going after the immune system too. as an aspect of law enforcement. I put that deliberately provocatively, but the idea is if we can get your antibodies to do the job of mopping up the drugs and you can't get high, this is a way of moving, so to speak, the prison walls within the body, right? Conscript the immune system. Now, I put it negatively. There's obviously amazing potential therapeutic benefits to this, right, as well. Drugs to disrupt memories. There's a team here in Saskatchewan that's done amazing work in the use of beta blockers, which have been used for a variety of medical purposes for years, including hypertension. But it has been observed that the amount of stress hormones released affects the strength of your memories and the quality of your memories. So there's a lot of interest in, can we disrupt your memories and therefore treat stress disorders, PTSD? Sort of a second generation of this thinking is, maybe we could use these techniques to try to weaken, dampen down the memories, the conditioned responses that cause drug cravings, that cue a drug craving. So there's a lot of interest now in whether that can be used as well in drug treatment. And my final example is so-called social neuropeptides. So these are various sort of hormones that seem to affect social cognition and behavior again, oxytocin and vasopressin in particular. And again, these are being used in social neuroscience, wondering, can we affect sort of aspects of empathy, trust, recognition of facial expressions, social bonding. And so there's exploratory applications of this in trying to address antisocial behavioral traits. Now, I put this example in to show you the interesting slide into preemptive thinking that occurs here. It's thought that young children with callous and emotional traits are at greater risk of developing psychopathy, and can we intervene early to try to get them off this course? And so here's a paper suggesting just that, and social neuropeptides treating with these kinds of trust and empathy and social cognition enhancing compounds, can we help them to get out of this path? Now, this preemption is another interesting, or I should say the slide into preemptive thinking is an interesting aspect of biological thinking of criminality as well, because if we know the cause, we have a target for intervention, why don't we do it earlier? And so that's as an example of this kind of thing. And again, once again, in addiction treatment. So why is it that these are so appealing? Well, actually, maybe I'm making a big presumption here. Maybe they're not appealing to you at all. I presume from the amount of research and the amount of talk around this that there is an appeal of this kind of thinking. Why is it that we like the biological explanations and treatments for criminality? And I think there's a number of reasons. There's one I've alluded to already. This search for explanations and solutions seems nicer than moral blameworthiness. Excusing people for things they could not do, could not have avoided, seems rather a humane approach. So I think that that's part of the thinking here. The other aspect is, if we say that there's a biological cause, well, whose fault is it? It's not ours anymore. We've located the problem within the offender. It's easier perhaps to avoid discomforting questions around what are the social determinants, the environmental questions. Although biosocial criminology, to be fair, does acknowledge the interaction between them, but still the focus of attention of the ultimate problem is the offender and his or her biology. Secondly, who must bear the solution? Again, a model which leans more toward the biological side means the intervention, unless we're going preemptively, is in the offender. And even if we're going preemptively, it's still in those individuals presumed to be on a track toward becoming criminals. Not us, in other words. We don't have to do anything to ourselves. Nor do we have to do complicated and expensive and complex attempts to solve social determinants of crime, criminogenic aspects of the social environment. And finally, there's maybe a commercial dimension here as well. Vretzko has written a really interesting article looking at drug treatment courts in the US and finding that the patent holder for a naltrexone formulation used for treating alcoholism is a big bankroller of the National Association of Drug Court Professionals. So there's ways in which the commercial interests come in to affect the ideology, the whole set of institutions and the direction in which they're going to go. So I want to sort of end up with a couple of questions to throw out to you. And these are the questions that I want to pursue further in the research that I'm about to start. And I've done some thinking along these lines as well. So starting out with this question that I started out with actually on the first slide, what kind of treatments can legitimately be offered to offenders? After all, if we think it's okay to imprison someone, then we must think it's okay to harm them. But not just any harm, right? Because if we set up a system where you could have your freedom if you agreed to physical castration, I don't think we would accept that. I think we'd say, no, you cannot put that choice to someone. There's certain forms of harm, even if the offender regards it as a lesser harm, that you cannot offer. Because that usually is understood in terms of cruel and unusual punishment as sort of the constitutional language that sets that boundary. But notice we are still in a situation where, looked at another way, offering physical castration or imprisonment might look like a benefit to the offender. You're offering a choice. Why is it not okay to do that? Well, there's something there that I think we'd be unwilling to do. And if we look at the jurisprudence in Canada and elsewhere on what is cruel and unusual punishment, physical castration, lobotomy, aversive conditioning are often mentioned. And in some places capital punishment too, but not everywhere. So if we assume that it's okay to inflict harm, then it's okay to inflict treatments or to offer treatments that it might impose some harm. But I think we run up against two controlling limits. One is that there's some things we cannot offer, even if an offender might prefer it to imprisonment, and that's cruel and unusual punishments. And secondly, who's going to administer all these treatments? It's going to be physicians who are themselves bound by particular ethical obligations of doing no harm. So as much as a legal system might like to offer harmful treatments, the physicians themselves will not necessarily be able to provide them. So there's another practical limitation on any system we might set up. So if we cannot do harm in this way, we cannot offer a treatment that does harm, how are we to identify what is harmful? Why is it that chemical castration seems to be fine, but physical castration not? Why is it that various psychiatric drugs seem to be fine, but psychosurgery not? Now, on a certain level, my examples, the answers are obvious. Some of them are, it's physical invasive, it's irreversible, whereas these other things might not be. Okay, so we've identified a couple of key criteria by which we identify which things can be acceptably offered and which cannot. But are there other things we should be thinking about as well in deciding what offers can be put? And I think there are. So I think, yes, we think about harm in its sort of obvious sense. Does it cause damage to the body or the mental health? Does it kill you? But I think we also have to look at harm and benefit, the level of autonomy, identity, and personhood. Because a lot of these treatments are working changes in identity. Unlike counseling, which is meant to sort of appeal to the rational mind, which in theory an offender could accept or not, the identity changes we're urging upon him or her. With these kinds of biological treatments, we go around the rational mind, right? We're building the limit in at the immunological level, for example. Is there something we need to think about in that context as a form of harm, of working identity changes, coerced identity changes that are not chosen? And there's very, very many interesting philosophical questions that arise here about what is identity, what's the value of identity, what is the nature, whose identity do we care about? Offender at time 1 might reject a treatment. At time 2 say, oh, thank God, I didn't have control, but now I'm really welcome it. Do we worry about the identity of offender time 1 or time 2? Think about the old story of Odysseus and the sirens as he traveled along and tied everybody else up so they couldn't leap into their doom, or blocked up their ears, had himself tied up. It's an expression of the fact that sometimes your desires or wills are not part of your identity. You reject them, ego dystonic. So if you help someone sort of chemically or surgically to achieve better self-control, which to them is welcome, is that a violation of identity, or is it an identity-promoting intervention? So these ideas of what treatments violate identity in a negative way are rather complicated in this area. Second question for you. What happens, and now we're just at the practical level, we're out of the philosophy and sort of abstract concepts of what is identity, but practically, what does a judge do if the offender shows up and says, I want access to this treatment, say physical castration. This, incidentally, is a case where this happened. Now, a judge could not order someone to do it. A judge could not issue an order saying, you must consent to whatever treatment your doctor orders, including physical castration. But what if an offender wants it? And then, what if an offender actually gets the treatment? In this case, this is what happened. Went and got physical castration, then shows up saying, now look at me, my risk is lower, give me the benefit of a shorter sentence. Now, all this sort of makes sense, but look at what's happened between the lines. A court which itself would not think it legitimate to order this or encourage this is now in a position of having to issue the reward for having it done, which in essence involuntarily implicates the court in encouraging that for others. Even if it wouldn't do directly, it now has to support indirectly. So what does a court do to avoid becoming implicated in this? And here we get into really interesting philosophy of technology and the way, the strange mechanisms by which we do or do not have control over technologies. When something emerges as a possibility, it becomes something subject to moral decision making and implicates us. The last question I put to you, and this is the one actually I think they're all fascinating myself, but I really am interested in this one, and that is, does the availability of biological treatments shift our judgments of moral responsibility for harms that we inflict on others? And so notice what's going on here. We don't talk about moral responsibility for things we couldn't control, right? It's not coherent to say you are wrong for not doing that thing that you couldn't do anyway. But what these treatments do is they give you information about your own predispositions, and they give you techniques to manage your own predispositions. So we've moved a whole realm of things that were formerly not within your control, now potentially within your control. They now become objects for moral judgment. Were you morally wrong not to take the means of controlling your behavior? Are we now going to hold you responsible for harm you did when you were incapable, when you knew and could have made yourself capable? Now, this is if you look at the history of how the Canadian courts have handled intoxication or self-induced incapacity, you see this tension all over the place of trying to import a mens rea from an earlier time, the decision to get drunk, to the time at which a crime is done while incapable. There's fascinating hints elsewhere in the law of this kind of problem, this kind of thinking, which Aristotle talked about this in Nicomachean Ethics as well, this responsibility to maintain your own capacity and virtue. So this is an old issue. But if we look at McLean versus Seisel, for example, which is a civil case in which a woman with serious schizophrenia but stable went off her drugs, having already had several episodes and warnings, do not go off your drugs. Went off the drugs. An incident occurred in which the police were called. In the ensuing melee, she was injured by the police and sued them and won, but the police countered with a contributory negligence claim saying, you are partly responsible for this, the harm that was done to you, because you knew and were warned not to go off your drugs. You did anyway, and you contributed to creating this situation. You're partly responsible, and this was upheld against her. So you see in the contributory negligence context, the judgment of moral responsibility for not maintaining capacity when the means were available. A lot more could be said about whether this was a reasonable judgment or not, but notice what is going on in that reasoning. And similarly, you can find hints of it in the criminal context too. I like this one in particular because it's sort of a laundry list of when you're not responsible. So if your impaired condition, had no diagnosis, so you didn't know about it, no foreseeability, you're not responsible, fine. That's consistent with how we handle things in law. If totally outside your control, also fine, you're not responsible. This is not a case of someone who voluntarily ingested drugs or alcohol resulting in impairment. That's a situation where you might be responsible. Nor is it a case of someone who decided to ignore medical advice or treatment that resulted in becoming impaired or impairment continuing. Another situation where you might be responsible. So another example of this kind of thinking, not just in the intoxication context of responsibility for actively taking steps to make yourself incapable, but in situations where your existing state is at risk of being incapable and you have foresight and ability to modify that, also now attracting moral judgment. So I think I better stop there. So I'll end there. I'd love to hear your questions and thoughts, and welcome to weigh in.